5 o'clock. Okay.
Yep.
Super. Super, super. Hello. Hello, hello. I think we've got, hi, Peter. We've got a couple of, a few people online. And I think that when people arrive, it's a bit of a different setup to what is usually done, in the sense that we have set up a system linked between YouTube and Zoom. So I see, do we have people coming in? I don't see. It's still very early. We'll have to wait 5 or 10 minutes, 5 minutes for people to come in. I think we've got a good connection this afternoon. The chat on the side of your YouTube screen is operating. So when you arrive and during the presentation, you can use this chat box. I've only got Peter who mentioned his name. There are more people arriving. 8, 9, 10. No one is mentioning his name on the in the chat box, but I'm sure that those who are arriving are very known. We have people from a bit everywhere in the EU this afternoon, probably from Ireland, from the UK, from Spain, from maybe from Portugal, Holland, Belgium. We are expecting Czech visitors, Slovenians, Greeks, of course. So there should be Peter. Hello, Peter. How are you doing? Another Peter. Yes, everyone is starting to arrive. Take your seats, take your tea. It's virtual, but it's civilized. Hello from BFNO. BFNO, yes. Hi, how are you doing? We should have a few people from BFNO. BFNO, for those who don't know, is the Belgium representative of the outdoors. Jan, hello. How are you doing? It's good to see you. Jan is president of UMLA, the association of the European Association of hikers and mountain leaders, accompagnateurs. Indeed, Brexit will be impacting their UK organization and the rest of the EU. Clara, hello, you made it, yes. Clara is a Czech lawyer who is who we welcome, and she's representing the association of the Mountain Association of Czech Republic, a member of ECHO. Peter, who else is arriving this afternoon? We've got 12 visitors already. I suspect it's like in any good meeting, it always takes 5 or 10 minutes to settle. And we'll be getting going very soon. Alors, okay, we'll wait another 2 or 3 minutes and then we will get going. The topic this afternoon, as you know, is Brexit and the consequences of Brexit on the UK. on UK operators from the outdoors, but also the consequences and I would say maybe opportunities for other outdoor professionals throughout the EU. And we will be able to get started in a few minutes. Alors, while we are getting organized and while people finish arriving, this afternoon I will be making a presentation. You will see there is two parts in this presentation. We will be talking about the aspect of right to work, which is an important aspect. But there is a second aspect to things which is equally as important, which is the recognition of qualifications. And of course, there are separate issues, but they are very important for the trade. On the issue of right to work, I will. We have invited this afternoon Tanol Feldman, who is Tanol is. I've known him because we know each other because we've been working on certain dossiers in the past, EU dossiers. And he's a senior partner in a company called Immigration Law Associates, EU Immigration Law. He's based in Brussels, and he's got a main area of expertise, which is labor mobility and labor and employment law and social security coordination, so EU-wide. And so Tanol I will be presenting the principle about right to work, but of course his expertise will be very valid to help us understand in the reality what the future may be for people, either for UK companies trading in the EU or EU companies employing UK citizens, because as we will see, the TCA, the trade and cooperation agreement, will have effect for both issues. And then we'll go back. The second part of this webinar talk show will be, as I mentioned before, about recognition of qualification. It's now 5:08, so we should get going because we will be finishing around 6 o'clock. It will take about an hour. And I'm sure maybe people will come in the meantime. So Brexit. There are two key documents that we will be referring to for those who are not familiar. One is the withdrawal agreement, which is the document that was signed in November 2019. Hello, Mikhail, from Czech Republic. The withdrawal agreement I will refer to, it's the WA, the withdrawal agreement. It's the agreement that's been signed between the UK and the EU and determines the ways, the procedure and the rights that prevail while the UK is exiting the EU, and it has effect after the transition period. So the withdrawal agreement effects is still pending, it's still binding, and we'll see later on why. But it's an essential document because it regulates the way the Brexit happened. And then, of course, there is a second document that is of key importance that you have heard of, the infamous Trade and Cooperation Agreement. We will refer to it as the TCA. The TCA was signed over Christmas between Boris Johnson and the EU, and it is the document that prevails as of the 1st of January in terms of trade and cooperation. It is available in every EU language since 3 weeks ago only. The whole month of January was dedicated to its translation. It's now available, and it still needs to be validated because it's temporarily enforced. But van der Leyen has said that it would be approved finally in February with no amendments, which democratically is quite interesting. But anyway, that's It's meant to be approved with no amendments. But we can say that 99.99% of its content will affect the outdoors in the coming years. Alors, what is it made of, this document? Because that's the base of what's going to happen to us. There is two keys. There is the goods and the services. On the goods, it will affect the outdoors a little bit, but not too much. In any case, the principle of this TCA is quite simple. Zero tax, zero quotas on goods, providing both parties respect the level playing field. Now, I'm not going to go into great details, but basically the level playing field is no different to EU rules previously, well, for the UK, that have been transposed into the TCA. So yes, the UK, in terms of goods, the UK doesn't have to respect EU laws anymore, but it has to respect the level playing field of the TCA. To be very honest, it doesn't change very much because the rules of the level playing field are relating to competition policies, subsidiaries, state-owned companies, taxation, labor and social standards. And at the end of the day, if the UK or the EU doesn't respect it, then taxation will come. So it's no big deal. The biggest deal of all is that, of course, on goods, there is no free movement anymore. So all the paperwork, the administration, everything has got to be done on top of the trading, which didn't exist before. Now, the key thing for all of us, for either you because you are running a company, or for your members because you are an organization, is the issue about services. As I mentioned it, since the 1st of January 2021, UK service suppliers have lost their automatic right to offer services across the EU as a principle. It doesn't mean that it's forbidden. It means that as a principle, they've lost their automatic right to trade. There are new rules that apply. There are two issues, as mentioned, that impact us as service providers, canoers, skiers, mountain bikers, etc. It's, again, right to work and recognition of qualification. On right to work, there are one aspect that we can deal with reasonably quickly, which is the residence. Obviously, if a UK passport holder is resident or becomes resident in France, for instance, he gains the right to work in France. On his CDS, on his carte de séjour, it says all professional activities. If he becomes resident in Italy, he gains the right, or she gains the right, to work in Italy. So if you have a mountain biker or a mountain leader or a ski instructor who is resident in Italy, he automatically has the right to work in Italy in any activity. I'm not talking about the recognition of qualification, which may be something that prevents him from working, but as a principle, he's got the right to work. Now, just to avoid a common mistake, and we've been asked many times on this issue, if I'm resident in France as a UK passport holder, do I have the right to work in Austria? The answer is very simply no. You have the right to work in France, but you don't have the right to work in Italy, in Slovenia, or elsewhere. If you are an EU member state passport holder, of course, you've got the right to work in every member state. But if you are a UK passport holder, because UK is not anymore in the EU, you only have the right to work in your country, in your member state of residence. If you decide after a few months to move, or a few years to move to Italy, for instance, or from Austria into France, normally you have 2 to 3 months to declare yourself and to obtain your right to work in the other member state. But as a principle, you only have the right to work in the member state where you are resident. Now that we've dealt with the residency, what happens to those who are not residents. So you are a UK passport holder, you are a ski instructor, you are a mountain leader, you are a hiker, whatever, and you want to go to work in Czech Republic, you want to go to work in anywhere in, in a member state. What happens to you? And what happens to your employer? Because the question is for individuals, but is also for the employers. Alors, there are different ways to supply service in an EU member state. Some of them don't raise any question. For instance, if you don't have to go because you deliver, for instance, I don't know, a training course online, you don't physically have to move from the UK to, say, Belgium to cater for your Belgian clients. Of course, there is no question. We are talking about the service delivery that requires that the UK passport holder moves from the UK into a member state, again, without being resident in this member state, because we've sorted that out. So we only talk about this aspect of things. The TCA has introduced 4 types of people who can move from the UK to the EU. By the way, everything I'm explaining is valid the other way around, is valid for EU passport holders into the UK. Okay, so I mainly talk about UK coming into Europe because we see it from a European perspective. But of course, the TCA is a bilateral agreement, and it's valid the other way around, obviously. Alors, there are 4 types of people in the TCA. There are the big corporate businesses. That's not us. There is the business visitors, they're called. There is intra-corporate transferees. That's the guys from Renault or Mercedes who go to see their. That's not for us. There are 2 types of people who are being dealt with, and you will need to remember, and that concerns us. They're called contractual service suppliers and independent professionals. Now, this is the core. In the outdoors, we don't have big companies. In the outdoors, we've only got contractual service suppliers and independent professionals. Alors, to make it simple, the first set of conditions for these bodies, we could call them, is upon their personal situation or the situation of their staff. For contractual service suppliers, one of the conditions is to be employed for your employees. So you are a kayak service provider in the UK. You are a tour operator delivering, I don't know, mountain biking, and you want to come to France to deliver your service. Your employees are UK passport holders. They must have been employed with your company for at least 1 year at the time you come to the EU. The employees that you are transferring must have 3 years professional experience, a university degree, and the required national qualification. But we'll talk about that later on. That's the condition laid upon contractual service suppliers. If you are an independent professional, you are a mountain leader, UK passport holder, you've got clients and they say, please take me to Italy to make the Tour du Mont Blanc. Take me to Slovenia to make some nice rafting. Take me to anything. You are an independent professional. You must hold 6 years professional experience, which starts being quite heavy because in our job, as you know, 1 year is in fact 1 season. If you want to have 6 years, you need to capitalize 12 seasons because we only trade in our jobs 3 or 4 months a year. If you are a mountain leader, most mountain leaders hike for 3-4 months a year. Most ski instructors operate for 3-4 months a year. So in order to show 6 years professional experience, you in fact need 12 seasons. You need a university degree or equivalent, and you need, of course, the required national qualification. So these are the two types of economic bodies that can come and operate in the EU. And these are the conditions that lay upon their staff or upon themselves if they are independent professionals. Now, there is another element to the big setup, is included in an annex. What I've mentioned is in chapter 4 of the TCA, so you can go and check. It's available in every language. We can send it to you if you need. It's in chapter 4. And then on top of chapter 4, there is an annex to chapter 4 that is called Annex Serving 4. If I remember well, in the English version, it's on page 747. And this annex is setting up restrictions. So you've already got some type of restriction or conditions for the two economic bodies. And then it sets a list of sectors, activities, jobs, if you want, that are backed by the CPC, which is a document from the United Nations that gives lots of details on who is included in these jobs. And there is a list for the, there are two lists, in fact, in Annex 4. There is a list for contractual service suppliers and a list for independent professionals. In the list for service suppliers, there are, the tour operators are listed, and those who are listed, normally, according to the TCA, should not face any restriction, limitations, whatever you want to call them. They should be not allowed, but they should be facilitated to trade freely. Of course, tour operators and tourist guides are on this list of contractual service suppliers. We are still envisaging if pure outdoor deliverers can be considered as tour operators, but we will see that with Tanol. He will mention that. We are searching. And then in the list of independent professionals, outdoor professionals are not listed. Alors, it doesn't mean if I'm on the list, I've got the right to come and operate in France, and if I'm not, I don't have the right. It doesn't mean that. All it means is that if you are on the list as a company or as a self-employed, you are on the list, but self-employed we're not. There should be no restriction to your operation. If you are not on your list, the only comment of the annex is the parties do not undertake any commitment for contractual service suppliers and independent professionals in economic activities which are not listed. So it's not prohibited, but we don't know. All we know is that the EU and the UK have made no commitment for those who are not on the list. So, and I will, just to sum it up, and I will then have Tanol coming in. On the right of work for UK outdoor professionals, UK passport holders, to deliver service in the EU, either you are a company and your staff needs 1 year professional experience and an academic, 1 year employment, 3 years professional experience and a degree or equivalent, or you are a self-employed and you need 6 to 12, 12 seasons, an academic degree, and of course, the diploma. If you are on the list, you should be able, if you respond to these conditions and you are on the list, you are free to come and trade. If you are not on the list, there is no commitment, so we don't know what's going to happen. We don't know. Now, I would like to ask Tanol to this is the grand principle. Now, in reality, and I'm inviting Tanol to join us. Hello, Tanol. You can. Yep, you are.
Hi, Jean-Yves.
Hello, hello.
Hello. Good afternoon. Good afternoon. Good evening, all.
It depends where we are in Europe.
But yeah, okay, here it's almost dark. Thank you very much for inviting me, and thank you for the nice presentation till now. Now, I will try to be as short as possible to give you the time to talk about what is the most important, which is recognition of qualifications. First of all, to date, in my view, and not only in my view, tour operators are tour operators, and unless a tour operator has registered outdoor sport activity, can you hear me?
Yeah. I was making sign to the studio.
Then tour operators are under the trade agreement, but not any outdoor activity which you are representing will be considered under the Annex 34. So I would say that for the moment, as a matter of principle, the outdoor activities are not under 34. So then the question is what to do. As you have mentioned, the fact that it's not under 34 it does not mean that, for instance, a mountain bike UK guide cannot operate in Europe as a matter of principle, as an employee or as a self-employed. The question is how to do it. Now, how to do it as a matter of principle, it's simple. We need to look, UK is now a third country, and we need to look into the immigration law of each one of the member states. Or eventually we need to look to see if there is any solution on EU level and how this solution is implemented on national legislation of each member state. So now again, as a matter of principle, because you brought this possibility of having these activities classified, however, under a contractual service provider. I think that we have the presumption that in order to provide such a service, you don't necessarily need to hold the university degree of minimum 3 years. So here that raises also a problem on the level of immigration law in each country, because most of the immigration schemes are open to highly qualified workers, and a highly qualified worker, it's a worker who holds at least a post-secondary degree of minimum 3 years, and still the degree must be linked to, in general, to the activity carried out. I mean, imagine, I don't know, an engineer which is also a ski monitor during the holidays. The problem will be, okay, I hold the university degree, but the university degree is not linked to the activity, to the job. Yeah. But however, looking on the EU level, there is a directive which is the Seasonal Workers Directive, which practically determines the conditions of entry and stay of third-country nationals for the purpose of employment as seasonal workers.
Which our sector may fall under.
I mean, we can see the sector. We can see the sector is a sector under seasonal regime, and this is recognized by national legislations in different member states, and it is recognized in the, I would say, in most important member states for you, like Austria, Italy. And now, of course, it's about a directive. So a directive is a legislative act that sets out a goal that all EU countries must achieve. However, it's up to the individual countries to decide on their own laws on how to achieve the goals, and right. Might make it a bit more complex. Now, so as regards in general this seasonal worker directive, it contains reference to certain business sectors should fall under the definition of seasonal work. Inter alia, tourism is there. So if you look at preamble 13, I think, of the directive, you will find out that tourism is one of the activities which should fall under the directive. Now, the question is whether or not your activity falls under tourism. It's a very good question. For instance, in Austria, it is clarified, more or less clarified, that the answer is in positive. Okay. Now, the problem is the following, and we are back, unfortunately, what you have just explained. The directive contained clear reference to facts that were about regulated professions. Okay. The directive underlines the member state right to require the applicant to present documentation attesting that the third country national, and now UK nationals are third country nationals, fulfill the conditions laid down under national law for the exercise of that regulated profession. Moreover, the directive shall not affect the right of member states to determine the volumes of admission of third country nationals entering the territory for the purpose of seasonal work. So we have, on the one hand, we have recognition of qualification, and we have quotas, and we have labor market test. Okay. Now, as regards the duration of stay and of course exercise activity, the directive provides for a duration of minimum 5 months and not more than 9 months in any 12 months period. Okay. After the expiry of this period, the third country national shall leave the territory of the member states unless the member state concerned has issued a residence permit under national or union law for other work than seasonal work. So seasonal work, it's clearly not residence in the host member state. It's clearly residence in the home member state. Now,
so Daniel, just to clarify on this, we seem to have some kind of, we've got conditions on the principle that I explained through the TCA. We've got conditions that are a bit heavy. It seems that there is a potential opening through tourism and the directive you mentioned, but even in that directive, the condition laid upon UK citizens is linked to their qualification.
It's not only UK citizen, it's about
to any third country.
I mean, here we need to have a look in a clear perspective. So now UK national, US national, or I don't know, any other third country national, unless a specific bilateral agreement between the host country and the home country of the national, it's exactly the same. So UK nationals, in addition to the trade agreement, they do not have any other privilege if you compare to any other third country national. Okay, so that's now it's the fact that they are UK national. It does not change the facts. Now, another important point in the directive, which I cannot, I mean, it's not necessarily clear under national legislations. The directive says the following, that as a matter of principle, the directive should cover direct working relationship between seasonal workers and employers. However, where a member state national law allows admission of third country nationals as seasonal workers through employment of temporary work agencies established on its territory, and which have a direct contract with the seasonal workers, such agencies should not be excluded from the scope of the directive. Okay, so here it's an important topic, because
maybe we've got some opening here.
Maybe. Okay. Now let's look a bit into what is going today. But again, what is going today is what is going today before Brexit. Let's see if certain member states will. I mean, here everything is possible. I believe you and others will try to negotiate a more favorable agreement, which is totally possible. However, I can see also member states which will, on the contrary, will do the best to eventually alter current legislation in order to make sure that they have less
incomers,
notably from the UK, when they have considered that they have too much, like in France, for instance. Now,
but you confirm that using the services of a temporary agency is worth checking and worth investigating.
Could be the national legislation of each member state should be checked, and then we need to see if any further development, positive or negative, further the Brexit agreement. So today, for instance, in France, for seasonal workers, there are residence permits which are valid for maximum 3 years. Main residents must remain outside of France. Now, of course, the stay, I mean, the residence permit is valid for 3 years, but the stay for work cannot exceed 6 months per year. Again, the problem here, the labor authority, it's the labor market test exists. The labor authority must approve. The employment contract must be sent to the labor authority, and the labor authority must approve. So there is a labor market test in place. Now, how France will react,
we don't know.
We don't know, because I mean, what we know that today, before Brexit, we faced a certain number of issues in France. So if it will be better or not, let's see.
Considering the way France have dealt with third countries when there was the directive, I'm not too sure how what's going to happen with that. But in your experience, these the work authorities, the ministries of work, who will have to deal with requests, what tools do they normally use? It's quotas.
It's vary from one country to another country. I will address immediately as another example, Austria and Italy. You'll see that the principle is the same. Is all quota, all labor
market. Not too fast, Tanel, because we don't understand.
It's not the same way in different member states. However, it can be a labor market test, quota, or both. Okay.
Right.
In Italy, we have both. In France, we have labor market test. In Austria, it's
labor market list. So it's list of shortage.
Test. No,
test.
Test. It's not the list of shortages. It's I would say it's a clear labor market test. Okay?
Right.
Why? Because you have a list of shortages.
And if you're in, they allow you to in. If you are not, they kick you out.
A labor market test is something which can be objective or subjective, and a widely a labor market test is subjective, like in France. Okay, in Austria it's a bit more clear, and in Italy you have I will present immediately. You have some decrees which are quotas which are issued on a yearly basis. So now again, this is today. Brexit is Brexit, and we are exchanging today. I believe authorities are also today sitting to decide what to do, and we'll see. Maybe new schemes will be opened, notably in order to encourage UK nationals to exercise certain activities and not other activities. Maybe certain member states will take advantage and to say stop forever. So this is something which we don't know. And by the way, it's your role to start negotiating as from today insofar as possible. So talking about Austria, it's a very interesting model. Austria, it's a pragmatic country. So in Austria, the model is based on quotas issued each year for tourism and agriculture and forestry, as well work permits which are issued by the Public Employment Service. Okay. Now, a work permit can be issued as a matter of principle only if the labor market test is satisfied. What is this labor market test satisfied? Whether the job can be filled with an Austrian citizen or a foreigner or citizen, which is an EA national. I mean, it's anyone available on the EU market. Now, who decides whether or not a labor market test should be carried out? It's notably the Public Employment Service. Okay.
Okay.
So we have seasonal workers which can be employed for a maximum of 9 months within any 12 months period. And we have another category, which are harvest workers, which can be employed for a maximum of 6 weeks under seasonal quotas as well. Now, here in Austria, at least something is clear. I am looking into the definition of tourism, which is not exactly in the law, but the Austrian Federal Economic Chamber has a kind of definition of tourism, which tourism and leisure sectors comprise the following industries: food services, hotels, leisure and sport facilities, travel agencies, cinemas, cultural and entertainment facilities, healthcare facilities. So at least in Austria, it's more or less clear that we are in.
But we may not find this in Italy, in Slovenia, or in.
Look, Italy. I also had. I mean, in Italy, it's. I think unless there is more restrictive measures will be imposed. In Italy, it's clear there are quotas, and behind quotas, labor market test, because the quotas are based on a labor market test. I mean, Italy, first of all, seasonal works in general concerns tourism. One of the sectors is tourism and hotel sector, so the tourism is there. Now, there are applications which must be lodged with the immigration authority. The permit is issued quite fast, in maximum 20 days, and is issued for the duration of the work required, with maximum of 9 months in any 12 months period. Now, under certain conditions, multi-year permits can be issued, which is also good. However, we are in a system of flows decrease which are issued each year and which provides for quotas for different sectors. By the way, what is good is the flows for
I think, yeah.
for seasonal workers are distinct flows. But again, we have quotas, and we have also, even if the quota is available, the condition is that no Italian or EU or non-EU worker registered in unemployment in Italy can fill in the job.
Daniel, just to summarize, for our friends who are either they are self-employed or companies in the UK, but this, of course, will also concern.
I'm talking about employment, Jair.
Sorry?
I'm talking only about employment now. Self-employment is differently. I will address in 2 words, but
yeah,
now
but
I'm talking about employment.
The principle of conditions will probably be similar.
In Italy, yes, because in Italy we have quotas.
What I mean is that this is valid for people who are going to come and incoming people, but also for people maybe in Slovenia, in Ireland, or in Holland who are employing UK passport holders.
I'm talking about people.
This will apply to them.
Yes, I'm talking about people.
Also.
I mean, I have addressed Austria, Italy, and France because I know that these are, in addition to
all the others are pretty much the same principle.
Slovenia, Czech Republic. I mean, of course, the rules are not exactly the same. We need to have a look into the national legislation. We'll find something which cannot be out of the framework of the directive, cannot be more than 9 months, cannot be less than 5 months in any 12-month period. We'll find either labor. I cannot imagine any country acting without a labor market test or quotas or both. So we'll find more or less the same. Now, again, self-employment, it's different. And I believe, for instance, in France, it seems open. I mean, in France, virtually today, a UK self-employed guy can merely, under certain conditions, proving that he has enough means of subsistence, etc., apply for a self-employed. I doubt that the French government will leave it like this. In Italy, we have quotas. In Austria, it's pretty much complex. I mean, it's a kind of.
So in Italy, there are quotas for self-employed as well.
Yes.
Right.
Now, in Austria, it's a kind of dream. I mean, it's a kind of dream. In Austria, you can apply for a red card for self-employment key workers. If your self-employment occupation in Austria creates macroeconomic benefits going beyond the own operational benefits. And there are some conditions which are heavy. I mean, you intend the occupation involve a sustained transfer of invested capital to Austria amounting to minimum 100,000 euro, or you create new jobs or secure existing jobs, or I mean, the criteria are not easy to
Okay.
So let's say that self-employment looks to be more accessible than employment, at least in France, not in Austria and not in Italy. However, again, about a niche which is probably very much welcome in certain countries. In other countries, the present shows that they have some problems with providers coming from other countries, including the UK, when the UK was part of the EU. So to see what exactly it will happen.
Okay. Thanks a lot for these precisions. Of course, as you can imagine, everyone, we can't take every single example because there are 27 member states and employers and self-employed, so that would be 52 multiplied by the number of activities. So of course, it's absolutely impossible to deal. But as you can see through Tanel, there's going to be, depending on where you are going and where you are employing your staff or contracting your service providers, because some of you have got businesses and they subcontract people from the UK in other member states. And as you can see, there is going to be issues with lists of shortage, with evaluation of economic reality, quotas, qualifications. There may be an issue with temping agencies. We are going to investigate this issue. Also, I've already made arrangements with some. we've established contact with UK hikers and skiers and canoes or kayakists to try to declare to obtain their right to work in different member states. The idea is to introduce test cases, because if we don't confront with the reality of the Ministry of Works, as Tanel said, and clearly ask them, okay, guys, this is what I want to do. I want this kayakist to operate in Slovenia. I want this guy to come to Ireland. We will not know unless we try, we seriously try. So we will probably in a few weeks, months, we will probably come back on this topic with more information. We will work with Tanel, with test cases, to try to see the pattern that's going to appear. But you can see that it's not business as usual. And as Tanel said it very clearly, Brexit is Brexit. We are in a new phase. We're in a new environment. Now, if it's too complicated in the short term, or if people don't want to take risks, there may be other opportunities, and maybe a Slovenian or a Czech company that was employing UK professionals could turn to Irish professionals, at least on the short term. I'm not saying that we as a sector should turn our backs to our friends from the UK, of course, but on the short term, we are doing test cases because we want to continue operating with the UK. Depending on the risks you are ready to take as an employer or as a tour operator, maybe you should seek possible arrangements with Irish staff, or with, I don't know, Dutch staff, Slovenian staff, Czech staff, or whatever. So you've understood the principle of the right to work. Resident is fine. Non-resident is facing different possibilities. We've tried to answer to some situation. As you can see, we can't possibly answer to every single situation, and we will be investigating this issue further. Tanel, thank you very much. I'm going to continue now on the second part, which actually will be a bit shorter, on the recognition of qualification, because as you mentioned it, one of the conditions for the right to work may or will be the fact that the UK citizens are holding the right qualification, or that it's been recognized. And so that's the other side of the coin, that's the other side of the story, is recognition of qualification. So let me go on this very topic.
Thank you.
Thank you very much, Tanel. And you stay online, because maybe there will be questions.
Thank you. Thank you.
Okay, recognition of qualification. It's reasonably simple. The Article 513 of the TCA lays out very little. In fact, the directive does not apply, since the Directive 2005/36 on recognition of qualification does not apply anymore since the 1st of January, which means that now the rules for recognition is down to each member state. So it's national law that applies to third countries and to the UK. And the TCA has set up a framework, what is a framework? A framework is basically it's the concept of if negotiations should occur, these are the topics that we recommend should be negotiated. Bon. So it's like the directive with just the headings and no content. That's the state of the game at the moment. There are two things that I wanted to mention. The first thing is that due to the withdrawal agreement, those who have introduced their dossier of recognition of qualification before New Year, before the 31st, are still covered by the directive. Okay, the withdrawal agreement, Article 28, plans that if your dossier was introduced before the 31st December at midnight, your dossier is still dealt with under the directive, which is a big bonus for those who've done so. If you suddenly introduce your dossier now, tomorrow, today, you fall under the laws, the national laws, and we don't know the exact conditions of recognitions. In certain activities like skiing, considering how the French, the Austrians, the Swiss, well, not so much the Swiss, the Italians dealt with UK citizens and their qualification when the UK citizens were protected and assisted and helped by the directive, we don't think that it's going to be more easier without the directive. I mean, I would be amazed that the French make it easier without the directive than they do when the directive applied. We also know that there are negotiations that are possible. Now, this will interest organizations like UMLA, professionals. The negotiations must happen profession by profession, but they will not be made member state by member state. If a profession wants to negotiate more or a better deal than what national law plans for third countries, these professions will have to negotiate with the EU. The competency of negotiations for recognition of qualification is the exclusive competence of the EU. I had a long exchange with the EU 3 days ago. They confirmed this very point, and it is actually based on a jurisprudence created by a free trade agreement that was signed between Singapore and the EU. And the TCA is a copy-paste on the basis of this FTA, of this free trade agreement. And the European Court of Justice has ruled that within free trade agreements, like the TCA, again, the negotiations can only happen with the EU. So if you are leading an organization, a profession, our recommendation is do not start negotiating. I mean, it is your responsibility to start negotiating with the EU through the Partnership Council that's been created. And the Partnership Council is the body that includes the UK and the EU. So you, as a profession, yes, do start building dossiers for the Partnership Council to modify things if you feel it. But again, don't waste your time starting to deal with each member state because they don't have the competence to deal with modification of the rules for the recognition of qualification. This also means for other EU members who used to employ UK citizens. If you do employ UK citizens, be careful that it is their responsibility to get their qualification recognized, but they don't benefit of the directive. So, how are they going to declare? How are they going to be recognized and treated? We don't know how. I mean, we know it's down to each member state, but be careful because, as you know, in certain member states, certain activities are heavily regulated. And if you start teaching or looking after customers without the required recognition, you may face fines and more in certain cases. So, voilà, that's the idea we wanted to deal with today. These two aspects of the new situation and the right to work and qualification. Maybe in the room there are a few people who would be interested to ask questions. You can type them in the little chat box if you have specific questions. We will, of course, in the coming weeks We will be by email, info@ECHO. You can ask us. We will be holding other meetings with ECHO. So you will be able to join and to ask further questions if you feel like it. I don't see many questions for tonight. I hope that what's the time? It's nearly 6 o'clock. We have delivered the info we wanted to pass on for today. We want to at ECHO, we want to take time to organize more of these, more webinars and chat, talk shows or chatting, whatever you want to call them, these sort of meetings. So we have a program that we've set with the board of ECHO. We've set up a program for the year 2020. What we'll do is that we will print it and on PDF and circulate it to all of you so that you know the dates. The idea is to meet at 5 o'clock once a month for the same on different topics. We've got topics about access to nature, handicapped in the outdoors, these sort of issues. So we will pass you the program. It's every third Thursday, if I recall well, or second or third Thursday at 5 o'clock. So the equivalent of today, if we are the second or the third Thursday of the month, and 1700 CET. So if you are interested in participating, we will be sending you links to this webinar, and feel free to join and to invite your members to participate. There is no immediate question, so I'm going to leave it to you. Tanel, thank you very much for your participation with us today. It's the first try that we do on webinars. Maybe you will have the occasion of coming back to visit us. We will be in touch on certain dossiers, as you know, Tanel. And if we've got questions, we will forward them to you. We will communicate your details as well if some employers are interested.
Thank you, Jean-Yves. Thank you all.
Thank you very much, Tanel. Thank you all. Thank you for being with us today.
Thank you for your time.
We will finish this webinar now, and we'll see you next month if we don't talk to you before. Thank you very much. Goodbye.
Thank you. Nice evening.
Thank you. Bye-bye, Tanel. Okay.